Going to go ahead and start recording. Thanks everybody for showing up. We're going to wait another minute or so. There was a little bit of confusion with the link, so we resent it out, but we'll start in just a couple of minutes. All right, I'm going to go ahead and get started. Thanks everyone for joining us. There will be more folks coming on, I'm sure, as we go along. Just want to let everybody know that this video is being recorded, so that folks can access it after the fact. So that's just an FYI. But thanks everyone for joining us. My name is Eric Sagrai. I'm with the North Carolina Office of the Juvenile Defender. And we are going to take a unique journey this afternoon. We are going to talk about juvenile first-degree murder roster and logistics surrounding that. So it is not necessarily going to be a substantive training, although at the very end, we're going to tack on one small legislative change that the General Assembly did just for those who are interested and practicing in delinquency court specifically. So today we are going to talk about how the juvenile first-degree murder roster is going to work. I'm going to start to share my screen. All right, everything looking good?
Yes.
All right. So before we get started, I wanted to say specifically that this is new. This process, what we're about to engage in, is brand new for us and brand new for you all. And we are all going to learn together moving forward. But we are going to do the best we can today to talk about how we anticipate the system to work. I think that those of you who do capital work, this is going to seem very familiar. Those of you who are not on the capital roster, this may be new to you. So we're going to do the best we can to describe the processes that we, along with IDS and AOC, are putting together to make this work. We encourage questions either in the chat or just sort of jump out there. And I'll be taking breaks to give folks an opportunity to ask questions as well. But again, thank you for coming, and let us get started. So we're going to start with a little bit of thanks for those of you who have already applied and have been accepted to the roster, and an invitation to those who haven't yet. We're going to talk about the fact that this project is going to be phased in based on the number of attorneys who have been approved for the roster. We're going to talk a little bit about the effective date and when we think this is going to be active. And then we're going to get into sort of the bulk of the discussion about how folks get appointed, how they get paid, and then how experts are approved and paid. We'll preview some forms, both from AOC and from IDS, on how this is going to work. And then, we'll open it up to any questions. And what's not on here, I didn't throw in, is this brief legislative update, but that'll be coming after. All right. So first of all, I so much appreciate those of you who are on the call, who have applied and have been approved for the roster. I appreciate the faith you have in us in doing this sort of unique project. I did want to share, I don't even know if I can figure out how to do this, in the chat, those of you who are not on the roster and are interested, there is the link to the application. And if you have any questions, please let us know. We are going to, starting in the new year, recruit again. I know there's some folks who applied and kind of maybe were midway through their application and hadn't finished all the processes, or some of you may have talked to me about wanting to do this and just haven't applied. We're going to really focus on this and help anyone who's interested fill out the application. We don't think it's so bad, but if you have any questions about that and you're interested, you can reach out to any of us and we'll be glad to help. So again, what you're looking at in the green are the areas in which this is going to happen. So for these 27 counties, these are counties that we have at least 3 attorneys who have been approved for the roster who are willing to take cases in these counties. Why did we do that? Well, I think that's probably self-evident, but if not, we see quite frequently that when one youth is charged either in juvenile court or an adult criminal court, there's likely a co-defendant or 2 or 5. And so we wanted to make sure that there was at least 3 folks who would be willing to take cases. Since we've been talking about this process in the last, I don't know, year and a half, 2 years or so, judges, prosecutors, public defenders, other entities have reached out to us to ask for assistance in locating attorneys. And as you can imagine, in many of those cases, there were several youth and adults charged. So we wanted to sort of err on the safe side as we're kind of phasing this in and making sure that there's coverage in those areas. And that's why we're sort of starting out small. Now, there may be some folks on the call today who have been approved for the roster but are not participating in those counties. That's perfectly fine. What we are hoping to do is that over time, add more counties as we go through further recruitment. So don't worry if you're not hearing something. The other thing I wanted to mention to the folks who have been approved for the roster is that in the coming weeks, we will be reaching out to each of you individually just to confirm your participation, the counties in which you're willing to go to, and your preferred method of communication when we're contacting you for appointment. So that's going to be happening in the next few weeks, assuming that, and I'll get to this in a minute, that the IDS Commission a week from today will give us the final go-ahead to go forward. The only difference, you might notice in the map, there's like sort of darker green and lighter green, and we just wanted to point out that in Forsyth County and Iredell Alexander counties, the chief public defender determined that they wanted to participate in our appointment process. And so we just highlighted those PD offices. If I'm not mistaken, every other county as of now does not have a public defender that we're in. And just there's the list. Also, I got to remember to do this. I will be sending the PowerPoint out to all of the participants in the training today. So don't worry. Hopefully you're not sitting there writing every name down or trying to get out a map and fill it out. You all will each get a copy of this, so don't worry about that. All right, so I'm throwing this out there. There's probably should be an asterisk somewhere. Um, like I mentioned, about a year and a half ago, the Office of Indigent Defense Services Commission approved the rules for appointment because to do this, we had to get the IDS rules changed. And that was approved in the spring of 2024. Um, but as in the ensuing year and a half, we've been working to finalize, as we'll discuss, the forms, the appointment process, the payment process, and it's taken us this long to do it. So next Friday on the 21st, the IDS Commission will meet, and I'll go before the commission and request that they formally give us the okay to start appointments in January. Um, as I think you all can probably also, surmise, even though the appointment is going to start in early January, it all depends on when someone is charged. So it could be sometime after that before, I contact any of you to take a case. Because, we know there's, uh, in these counties alone, annually, there's maybe 50, 60, 70 youth charged. And it fluctuates. So it's not a whole lot of cases. So just know that, don't be concerned of like, oh, I haven't heard from you. Well, it's likely because no one's been charged. So I just wanted to put that out there. But we're not going to the process is going to start and I'm looking at it, it's funny, it looks like legislation, but it's not really. That it's for offenses committed on or after that date, and what that means is that only the youth that we sign the appointment form for will then be in this process. So if you're currently representing a youth, and for example you want more expert funds, that's still going to go through the process you're doing now, which is the judge. But for the cases coming after this, all of the processes will be instituted in the way I'm describing. I hope that wasn't confusing. But just to make sure that it's only for the cases that where the kids are actually charged after that date. It may be the first, it may be whatever that first Monday is, it may be a week from that, I don't know, but it's going to be somewhere we think in January. I think we're going to be good to go. And just to clarify, but I'm sure as everybody knows, we're just doing 13, 14, 15, 16, and 17-year-olds. Why? This is specifically to represent youth facing life without parole. So if you're 10, 11, and 12 and charged in juvenile court, you can't get transferred. So, and the worst case scenario, you'd be going to a youth development center, YDC. So this project is only going to cover those youth that are eligible for LWOP. That's the whole thing. That's the whole reason we're doing it. So if there's a question about that in your jurisdiction or you hear something, just let us know. And I'm going to say about 100 million times during this training, there is no bad question. Please feel free to contact us if there's ever a question about what the heck is supposed to be going on. This is going to be our focus, and we're glad to assist. But as the law stands right now, the 13, 14, and 15-year-olds would start in juvenile court and then be subject to mandatory transfer, either PC or indictment. And then the 16 and 17-year-olds would start in adult criminal court. So as everybody knows, that changed just about a year ago. It was from 2019 through basically the end of 2024 that all these youth started in juvenile court. But as of December 1st, 2024, 16 and 17-year-olds charged with first-degree murder are starting in adult criminal court. Now they can be removed to juvenile court. We're not really discussing that today, but that is possible too. But this is where they start, and this is where you would get appointed. Because it's LWOP, we're really only looking at felony murder or premeditation and deliberation. I know those of you who practice in delinquency court, and I think this may also happen in adult criminal court, sometimes you get the charging document says with malice aforethought. We see this all the time in delinquency court. I think basically, and I saw David Andrews is on the call, but I think basically the Court of Appeals has said that that's fine to charge for first degree murder. I guess the point is, if there's ever a question about that, just let us know. But like you see in the PowerPoint, this is kind of in delinquency court. If you haven't been there before, it's with malice aforethought, but it's listed as first degree murder. And so we're going to probably go ahead and appoint you. And if something else happens, we'll figure it out. All right. Any questions or comments so far? I cannot see the chat. All right. So, how's this going to work? Well, when a youth is first charged either in delinquency court or an adult criminal court, because the process starts and likely they will be in custody, we're telling the clerks and the judges, go ahead and appoint somebody locally to that initial hearing. In juvenile court, it's the initial secure custody hearing, which has to happen within 5 days of being picked up. And so, we may not know about it until after you have the initial secure custody hearing, and then we will work to appoint roster counsel at that point. But we're telling them, go ahead and appoint provisional counsel, let us know, and then we'll move on with roster counsel. I think that's probably all I have to say about that. And then those folks, by the way, will still file whatever they're doing in that jurisdiction. They'll file a FIAP. They might be in adult criminal court and doing OASIS and might file that way. They may be a contractor. It could be that the two coincide. Like you might be the one to be appointed provisional counsel anyway, and that's great. That helps us out. But I'm still going to contact you and say, are you okay with keeping the case? So don't worry about that. If you like, right now I'm kind of overloaded and we, talk about load bearing, but chances are it might not be somebody on the roster. And so we'll go from there. But we just wanted to let you know we had thought about that. And this is also included in the IDS rules. So, and I'll show you sort of a version of this as we're going along, but there's going to be a notice and determination of counsel. And Terry, jump in any time because she's, really been over the forms. But one thing we have really striven, is that a word? We have tried to do is get one form for both courts, right? So we don't have one set of forms that's going to deal in Superior Court and one set of forms that's going to deal in Juvenile Court. We thought that was too confusing. Nobody wanted to do that. So this AOCJ 446, which is, I can say it's on its way to be final, we hope, is going to be used in both courts. So don't worry if there's, some confusion about that. The other thing I would say, and I'm not sure, we're just going to have to see how this works out. I know that in some jurisdictions, if a case starts in delinquency court, it's mandatory transfer. In the delinquency court, like physical setting, the district court judge, hears about pretrial release, sets a bond, and the case moves forward. The next time when it gets into adult criminal court, I think either district or superior, sometimes the judge may think that they need to reappoint or appoint somebody else. We're trying to prevent that. And that's my message to the bench. But if it's a problem, let us know. If they're like, no, my understanding is I need to do this, then have them contact me, or us or whatever, and we will straighten them out on that. But once, if it starts in juvenile court for the 13, 14, and 15-year-olds, we don't need any other determination. right? It's been determined. This is the whole point of having this roster. It's been determined you're going to be the attorney now for the length of the case until the case is resolved for this young person. But again, I'm recognizing that in different jurisdictions it may happen differently. Just let us know and we'll work it out as we go along. We're perfectly, aware and prepared to do that. We're going to be looking for issues because it's new. And so there's going to be some bugs in the system and we're going to do our best.
Just one point on that, Eric. If you are in a jurisdiction where you're struggling with that, they do still have to do the first appearance once it transfers to Superior Court because the punishments are different. So they do need to be re-advised. So we're not saying don't do a new first appearance in Superior Court. We are saying don't reappoint once it gets to Superior Court.
Thank you. And even if they say that, they'll just reappoint you. So hopefully we can figure that out. So as I mentioned before, we're going to ask every roster attorney individually how they'd like best to be contacted and what your preferred method of communication is. And, we're going to try to give them an answer within 48 hours. That may not be tenable. I'm not promising anybody anything, but in the last, whatever, year and a half, 2 years that we've been doing this kind of informally, we've been pretty successful. Sometimes it takes a few days and that's fine. But that's going to be sort of an aspirational goal, let's say. That's what we're going to try to do. So then there is going to be an appointment of counsel form. We think it's going to be AOCJ 447. And we're going to notice the clerk via file and serve. So yes, we're going to be part of the Odyssey of Odyssey, just like everybody else. Hopefully this is going to work smoothly. And again, we've talked to the judges, we're going to talk to the clerks and hopefully figure out the best way of doing this. But if something doesn't work out, we're going to know like what's happened and we'll be aware if somebody comes to us with a question. It's not going to be, oh, I just sent it off and everything's going to be fine. I'm not going to worry about it. We're going to be very mindful on that. I saw a question pop up, but I don't know if I can.
It says, does the procedure or form address, or does OJD have guidance on the difference between presumption of indigence under the juvenile code versus application for indigency under the adult statutes in relation to first appearances?
No. I think the determination of indigency hasn't changed in juvenile court. If the case starts in juvenile court, they're getting a lawyer, and there's no question. In adult court, yeah, the question has to be asked. I think we sort of know that in all likelihood they will be appointed an attorney, and if they don't, I'm not sure. We wouldn't even know about it, but I don't know, and maybe people see this happening. I don't suspect that'll be an issue, but it's a good point for us to look for. And then of course we'll get all the information we can to the court about notifying the attorney and making that connection. So again, because this is new, we suggest that even though we're notifying the clerk, some redundancy wouldn't hurt. I know everybody's got a lot to do, but if you think about it, please also notify the clerk that you've been appointed, and also make sure that you've got elevated access in Odyssey, so you can see everything going on in the case. All right. I'm going to pause for a second. All right. So this is kind of a package deal situation. When we were sort of looking at broad, sort of policy considerations, and we've had many conversations with the Office of the Capitol Defender. I can't thank Rob and Michael and his staff enough. They've been very, very accommodating to us. We just thought for ease of, deployment, it made sense just to sort of follow what OCD has been doing. So again, the forms, and now these are IDS forms, right? Not AOC forms, but IDS forms. What you're going to see if you're on the capital roster is very similar, because we took those forms and we just modified them a little bit. We obviously were not interested in recreating everything. So for some of you, it's going to be like, oh yeah, I'm familiar with this process. So you would send us the ex parte request for expert funds, and I'll throw, I think I've got that in the PowerPoint. I'll throw up the form. You'll see it's got a lot of the same information. And again, for those of you not on the capital roster, right, this is the difference. Like right now, if you're not doing capital work, you're used to going through the judge, but now you're going to go through us. And again, just to reiterate, this is also in juvenile court. So I know sometimes things in juvenile court may not be, oh, I understand why you're doing this. Like your client, may be charged, the petition is filed and you're still waiting on the grand jury and you're asking, but you could go ahead and ask for this, right? You don't have to wait till the kid's transferred. You can go ahead and send us, these requests. And I know as we've been talking, to juvenile defenders in particular, when they're doing these cases, I mean, they're jumping on this right away, getting a fax investigator. Maybe they're asking, well, what the little tricky thing is a forensic evaluation. I wasn't planning on talking about that, but maybe I'll mention that in just a second. But going ahead and getting a mitigation specialist if they think that, we're looking possibly at a Miller hearing down the road. What I just mentioned about capacity, and I hope I'm not going to confuse myself and others. So I think, and Yolanda, correct me if I'm wrong, as part of the 2024 legislation, it states that for capacity to proceed, like you supposedly cannot challenge under the law a youth capacity before they're transferred. That's what the law says. What we've been talking about is, well, we feel like that's a constitutional question of law. And if you feel like you need to look at that before the youth is transferred, and you want a forensic evaluation, and you want to do it privately and not through the not request the court, because if you request the court under the statute, you're probably going to get refused because they're going to say, well, we got to wait till it's transferred. But if you want to contact us and try to contest it prior to transfer, you would still go through this system. Does that sound right, Terry and Yolanda? We hadn't really talked about that, but now as I'm thinking about it, right? Okay. But that may not be the case, and you might get the indictment very quickly and you're already in Superior Court and that's a non-issue. So we'll take a look at it, and we'll return it. Again, I've been in a lot of conversations with Rob, and I'm probably going to follow a lot of the same sort of standards he has in approving expert funds in increments, submittal of their policy. And we are going to maintain, a catalog of funds that are approved, just so, it's for a lot of reasons, so we can figure out how much money is going out. We can figure out, on average what's going on, sort of for policy reasons. So this is why we're doing it this way. All right. So for payment. So I think as many of you know, but if you don't, just a few years ago, I believe it's been since 2022. I want to say January 2022. Payment for these cases is $100 an hour. It is the same as capital work. So it's not 85. Those of you who maybe do the high level felonies are used to the $85 an hour. But for youth facing life without parole specifically, it is $100 an hour, the same as capital work. So wanted to make sure everybody knew about that. This is another new AOC form, AOC J448. And so if you're on the roster, you'll fill out that fee app and send it directly to me. So you fill it out, you e-fax it or email it to me. I sign it as the designee of the IDS director, and then I send it directly to finance at financial services at IDS. So just to reiterate, this is one of the differences, right? Because right now, you're going to be going through the judge, whether it's in delinquency court or adult criminal court. But now you send it to me, I signed it, and I send it to IDS Fiscal. And those of you who don't know, I'm actually like 10 yards from those people. So if an issue arises, we'll figure it out. Like we're right here and we'll be able to figure out if there's any hiccups in the system. Now, just like you do in other cases, because either in juvenile court, the judge can consider recoupment, but it's not mandatory, or in adult criminal court, the package will be sent to the judge for recoupment. Again, similar to probably what you've been used to, but otherwise the payments will be coming through us. So you don't have to go through the court. Any questions so far on that? All right. So as I mentioned, I forgot how many of the forms, but this is kind of what it's going to look like. Like those of you who have submitted to Rob are probably familiar with this form. It's very much the same, except obviously we've got juvenile first-degree murder cases, we've got the age, we've got our e-fax number. I'm going to give that to you at the end, and this will be distributed. But very, very, very much similar to what you've been used to. Just wanted you all to get a look at that. And the other thing now that I'm thinking about it is, once these forms will be available, I believe, well, the AOC forms will be available online, and I will ask IDS to put them, they'll both be on our website, but I'll also ask them if they can to put it on the main IDS website. So you've got two places to look. But we'll also send, blank PDFs to folks just so they have them. This is the award of expert payment. Again, probably used to seeing something like this. If you're on the capital roster, again, we've clarified it for youth 13 through 17, has our contact information. But other than that, mostly it's the same as the other form. And then here's a summary accounting for expert fee applications. So you can submit that and we can keep up with it. All right, so what I don't have the AOC forms, but we can get copies of those once they are finalized to everybody. While I'm on this, I know Chad Boykin from Associate Counsel for IDS is on. Chad, did you want to jump in and say anything, or have I done okay?
You're doing good. If anybody has any confusion about, if I'm a MAC contractor or if I'm this or if I'm that, I'm glad to jump in. But as far as this process goes, you're in good shape.
Okay. And again, I'll just mention if some of you are coming on late, at OJD and at IDS, we have finalized the forms. We just need to get the AOC forms to them for finalization. So I think we're in good shape. The specific two contacts are myself and Terry. You can also contact Yolanda. We've got a small office and we talk all the time. So the number that is on your screen, and let's see if I can get the chat back up again. I will put it in the chat, is my cell number. And this is, I don't have a state phone. This is my personal cell number if you don't already have it. Those of you who have contacted me in the past know I'm pretty responsive. But that's That's how you get in touch with me the fastest. I don't know why there's a little thing there. Hold on. Hold on. Just trying to fix my phone number. All right, there we go. But if you ever have a question, text or call, you can, of course, always email, but just want to make sure you have that information. Well, I talked pretty fast. What a surprise. Let me open it up to anyone who has any questions, or was there something we missed? Again, you know, there could be some piece of this we haven't thought of. And so we want to make sure you all had an opportunity to ask any questions about that.
I have a question.
Okay.
For experts that we're going to use for these cases, psychologists for juveniles are impossible to get. They're all insanely booked up. Do we have a list of potential resources for us to use for those types of things for those people?
We have not put anything, it's a good question, Cindy. We haven't put anything together specifically. We have thought about that, and we need to look into that more carefully. Everybody knows the go-to folks around the state. And you know, we work with Sarah Olson to try to figure out who's there, but we need to seriously consider putting together, whether it's mitigation or other experts, you know, that are really interested in doing this. I have intermittently had some you know, experts come to me and, you know, are really interested in working with youth. So thank you for suggesting that, and that's, we're going to look into putting something together like that specifically for this.
Thank
All right.
you.
Yep, I saw John. We discussed the private availability would be given a. So John, you figure out who you want the expert to be. And you let us know, and just send in the forms, and we'll go through that process. So yeah, that's you all. And Beth, thank you. Yes, please share. If you feel like they'd be okay with us passing their information along, we'd love to see that.
Eric, I think there was a question from Mary right above John's.
Yep.
When do you
So Mary, I would have them go ahead, and I think you saw the link. If let me just, I know there's been a few questions, so I'll just re-put the link in the chat. Have them submit through here. If they have any questions, call us. We are going to be reviewing coverage in the first few months of the new year and seeing if you know, we can find enough, you know, the three folk minimum, 3 attorney roster minimum to cover more counties. What I would also say, because I know you all are in a public defender district, and Beth, and I think I saw Jana on the call, the roster is what we're discussing today, but I would also say that I just really appreciate those who've been on the roster and not on the roster for still accepting cases in counties where the roster isn't active. And so we're going to continue to try to assist those counties while we're doing this official process with the roster. So that's not going to change. So let us know, even if you're in a non-covered district or county, if you need assistance, you know, we'll be glad to help you find somebody. Thank you, Beth, for sharing that.
Thank you.
Oh, that's a good question, David. We have not. So David Andrews from Office of the Appellate Defender, if you don't know, asks about a separate listserv. We haven't made a decision. Largely, I've just had one email list. Part of me feels like there's a million listservs out there, and we just haven't figured that out yet. And because it was only, you know, 29, 30 people, we were just sort of keeping it local. But it's a good question to consider. And anybody who wants to be on the juvenile defense listserv, let us know. As we are moving like for resources or expanding the roster, I will let you know, because some of you are on all of the rosters, but I think you've seen, we've sent it on information on the juvenile defense listserv, the assistant public defender listserv, the IDS contractor listserv, the chief public defender listserv, and the capital listserv. So I apologize if you're getting something like 6 times, but we're trying to reach people as much as we can. All right, these are great questions.
Eric, I thought I'd ask another question if that's okay.
Sure.
You mentioned folks can ask for experts when the case is in juvenile court. I mean, do you anticipate granting multiple requests early on, for example, for a mitigating specialist and a psychologist? I mean, these are things that I would probably immediately ask for. And you know what I mean?
Right. And I think, like a lot of other things, some jurisdictions are used to that and some aren't. And some of it, quite frankly, is just how often these cases are happening in certain places. There are certain cases, because of their population or whatever reason, may only see a case or two a year.
Right.
And so this wouldn't be maybe as regular a process as it would be in some other jurisdictions. But yeah, I mean, our internal policy is, please reach out early to get these things underway as soon as possible. That is definitely what we're promoting.
And I don't know, I've never really thought about this, but is there like a presumption, any sort of showing you have to make? Just that you've been appointed and you anticipate you'll need an expert, I guess.
Yeah, and if I have any questions about a request, I'm going to reach back out to the attorney and ask if I think there's an issue. But while, and this is another thing we may want to think about, while we don't have like articulated specific standards of, thresholds you need to make, I think we all know what is needed as a baseline, and I do not anticipate questioning that.
Yeah. Thank you.
So there's a space on the form for the request for the expert to give a brief description of what are the fact specific pieces of the case that make you think you need a specific type of expert. So a ballistic expert, for example, if you thought you needed them, you can put that on the actual form. And obviously, I think most people hopefully know on the call, you can have a separate motion and order for purposes of here's why I need an expert authorized. Usually it's the Aki versus Oklahoma. I think there's a motion and order on our website, and I know there's one on IDS's website. So if you need the language and what's required, or if you think you're just not quite sure, you can look at those.
Thanks, Terry.
All right. Well, oh, I see, Deb. Will there be a separate juvenile life listserv? So my answer is we haven't. The answer is unclear. We haven't decided. But for right now, all of the folks who are on the roster, I just have one email list, and everybody on the roster is getting the same information via that. If you all think a separate listserv would be a good idea, I will definitely look into that. I didn't want to do it and overwhelm folks. Yeah, so we'll look into that, and if everybody's okay with that, I'll ask when we're asking about contact information, we'll make that a question and make sure everybody's okay. I just didn't want to continue to bombard folks with a million listservs, until we could figure out a better process. But thanks, Deb, for the question.
Eric, I have one more question.
Sure.
Sorry. And I may have missed this when you said it. When when cases like this come in or need appointment, and you have, say, 3 or 4 attorneys that work in or are willing to work in whatever county or whatever area it was where this happened, is the request for you to take this case going to come out in like a text to everybody, like everybody gets it at one time and whoever responds first? Or is it going to be like the Capitol Defender's Office where they send it to one person, and if they say no, then it goes to the next person, see if they. Okay.
Yes, thank you, Cindy. That's a great question. No, we're gonna ask individually. And I appreciate that, because when we get like non-roster requests, you're right. Sometimes we just sort of put it out there. But for this, when we get notified, we're gonna ask folks one at a time. So great question. Thank you. So David, to your question, and somebody on the adult side can tell me better, but yeah, I mean, in juvenile court, you know, if for whatever reason the case is resolved in juvenile court, the judge should be speaking to the parents about it. But in adult criminal court, I think it's just the client. Unless I'm missing something. Yeah. I mean, be great if we resolve some of these in juvenile court. That would be wonderful. You know, I know you all do great work, and sometimes this in fact happens. But I think it's only there when, you know, if those of you who don't regularly practice in juvenile court, so recoupment. Okay, so backing up a little bit, you're automatically assigned counsel. The indigency is presumed. The judge can order recoupment, but usually makes an inquiry. There are some jurisdictions in the state where that inquiry is never made, and it just doesn't happen. But there are other jurisdictions where it does. And so, assuming that few and far between of these cases will be resolved in juvenile court, that would be the process. And, you know, thanks again, you know, to Chad Boykin, who's on the call. We had a lot of discussions about how that would work and how that would work on the form. And when you look at the FIAP, you're going to see that there's actually a page on juvenile recoupment and a page on adult criminal recoupment. You know, we just needed to cover the bases, even though it is unlikely it will be resolved in juvenile court. We do have that covered on that form. So it's there.
I'm sorry, I have another question.
Go, Cindy.
I'm sorry, I promise. I don't mean to do this. So when we have juvenile cases that get transferred, not homicide cases that get transferred to adult court, very often in resolving it in adult court, if they get a probationary sentence, we ask the court not to force them to pay the attorney's fees, supervision fees, just because of their age, the fact that they're still children and are presumed indigent. And a lot of times we'll ask the court to waive those. Obviously, with these kinds of cases and a higher rate of pay, those attorney's fees are going to be pretty substantial. And I think it ultimately hurts the PAC fund if we don't recoup some of that money. So is it going to be something that's frowned upon if we say, please don't make this child pay, you know, my $17,000, you know, or whatever it is, attorney fee? Is that going to hurt IDS and the PAC fund down the road if we try to get the court to say, no, you can't make this child pay this because they're a child?
That sounds like a Chad question, maybe.
Okay.
Here's what I will say, and it is, you're identifying something absolutely correct. Basically, this is not our rule. This was the legislature that said roughly about 1 month out of 12 of our funding comes from recoupment. But to put it in perspective, the amount of judgments that are out there are about 1.4 billion. And what actually gets collected is through set off debt is like 5 million per year. So the majority of this is uncollectible debt. These are people who are no less indigent than they were when they filled out the indigency petition, particularly kids. So no, even though our funding comes right as, we would not advocate to you, you know, to do anything that would not be in your client's interest. And we're, you know, the processes will keep functioning But you advocate for your client, and I would not worry about that. This is ultimately a judge's determination as well. Basically, just like in the capital process, when this is all done and the amounts are paid, then this packet gets sent to the court and the judge will make that determination. And as I think Eric pointed out, there's some places where they don't even make the inquiry, but in some places they do. But no, we're not going to tell you not to advocate for your client. And yeah, even though yes, you're right. But as a percentage, it's a drop in the bucket.
You know, if you get a good outcome for a kid charged with this and he's got a future at 30 or 35 coming out of prison, you don't want him to have this obscene judgment out there hanging on them that they're trying to start moving forward with their life and this thing's hanging over them. So that was my concern, was we don't want to set them up for failure after we're done either.
Yeah, and the original sort of case law, I think it was Fuller versus Oregon from like 1974. It was all predicated on there didn't just have to be a colloquy with the client. It was like there had to be present ability to pay without hardship. State versus Friend, which is our state's case law from 2018, doesn't talk directly about that, but that is part of that determination, right? Is there a present ability to pay without hardship? So in these hearings, when they happen, that should be part of that discussion, right? Does this person have the ability to pay without hardship?
Thank you.
Sure.
Thanks, Chad. Thanks, Cindy. Okay, so I wanted to answer some questions on the chat. So Charles was asking, when do we know what jurisdictions will do the program? So I just threw the map back up again, and it will be these counties in green will be activated at the same time. Once we get the final okay from IDS, we will decide on a specific date and we will get that out to everyone. Also, if we get assigned, even if someone else is assigned in juvenile court, I'd need to get on the, yes, I think that the answer to that is yes. As I mentioned before, we're not going to go backwards, you know, with cases. It's just those cases moving forward. And if you have any questions about the roster, let us know. So Deb is asking, I would take a homicide in Wake and Harnett. Is there a different procedure in Wake, not on the map, than Harnett? Yeah. So Wake County, the public defender in Wake County is still going to appoint in these cases. That's why they're not listed here, because the chief public defenders were asked if they wanted to opt in or opt out, and the Wake chief public defender decided not to be part of the program. So that's why it's not there. Okay, so so yes, if there are cases in the county of appointment that are related to the charge and to that person, yes, you know, we'll be glad to take a look at that. I mean, I would only sign the paper, but I think in the rules, Terry, correct me if I'm wrong, that says any related cases would also go with that lawyer.
It does say any related. We did not specifically address if there were other just pending cases, but we did put related in there.
Now, the other question, Deb, is what if that person is charged in both count, you know, and then I think, you know, like, let's say you got appointed in Wake County for that person that's non-homicide, but then they get a homicide in Harnett, you know, it's perfectly fine for you all to you may know before we do in some circumstances. And so please let us know and we'll see if we can go ahead and do that. So it may have been that, Deb, you wouldn't have been the first person I would have contacted because we had just appointed you on something else. So we were going to go to the next person, right? So I think that's perfectly fine to just let us know when you see something coming. So Alita, so Johnston, so those cases are gonna be appointed centrally. But I've talked a lot with Trainum and, you know, she's gonna probably come to us with some suggestions. And the other thing is, I'm not gonna predict one way or the other, but it could be that in the public defender offices that it would have otherwise been covered by the roster, would have that may change over time. We don't know. And I don't want to predict one way or the other, but I think that's possible. How do we pick counties if we don't have those counties? I think your choice is just where you want to practice. You tell us where you want to go, not the other way around. You make the decision about, what counties you prefer to practice in and let us know. And then we'll let you know, when we have enough lawyers, once you're on the roster, that county is active. Yes, you can call me. All right. Well, I know we're almost at 2:00, and I just wanted to spend a few minutes talking about a couple of changes in the law, in case you didn't know, because this was sort of under the radar a little bit when House 307 was passed. Here's the bonus. All right. So sorry, I know this is sort of changing lanes a little bit, but because we're not going to do an actual legislative training this year, we just wanted to throw a couple of things in about probation extension and post-release supervision extension. And again, I'm just sort of holding up this is House 307. All right. So, and this does apply to you all to some extent if your cases do get finalized in in juvenile delinquency court. So right now, the terms of probation are 1 year plus an additional year for everybody. It doesn't matter what you've been adjudicated of. You can be adjudicated of a class 3 misdemeanor and spend 2 years on probation, or you can be adjudicated of a much more serious felony, robbery of a dangerous weapon. You're not committed, and you can get 2 years for 1 year in addition for 1 year. But what this does is that it extends for A, B1, and B2, and pay attention to those, because when we talk about post-release supervision, it's going to be a little different. But the other main difference is this is not mandatory. It's discretionary. The court may extend the term of probation for an additional period of up to 1 year. So basically, for these offenses, if you're on probation in juvenile court, the court has the ability to extend you for another year so you can be on probation for 3 years, right? So I think this is just, I don't want to presume, but I think this is largely, the General Assembly's concern about more serious offenses. And so this is, for both of these, again, offenses committed on or after December 1st of this year coming up. So similar legislation, post-release supervision. Now, two differences here. So back with PRS, if you're not familiar, post-release supervision after you're released from a youth development center has to be 90 days. And it's 90 days for everybody. Again, they don't make a distinction between what you've been committed for. You could have been committed for your 5th misdemeanor, and you get 90 days. You could be committed for a 12-year-old for first-degree murder. 90 days. It just doesn't matter. But now what they've done is they've made a change for A, B1, B2, and C felonies. Again, notice this includes C felonies. I have no idea. I don't know why this includes C and the other one doesn't. Also, notice the language here is must. It's mandatory. Other than, comparing it to the probation. I don't know, but that's what the law says. So you have to complete 3 years of post-release supervision once you get released from YDC for A, B1, B2, and C felonies. Now, those of you who do this work probably are already recognizing a problem, right? Because this is going to run right into how long they can be in the juvenile system at all. Jurisdiction has got to end at 21, period, right? So, I mean, I can imagine, I guess you can get a very young child who, maybe is committed at 11 or 12 and can go to YDC for a year or 2 years and then spend 3 years on post-release supervision. I don't know. Well, anyway, I'm not going to try to opine, but this is the new law. Also noticed in both of these, that the prosecutor is supposed to provide the victim to talk about what they think about the youth in the case. I'm just going to say, I believe I know the case that this is referring to that sort of led to these changes in the law. But it's neither here nor there. This is going to be the law for youth who were charged on or after December 1st. I don't have a whole lot to say about strategy. What I would say is, obviously, for these youth, for these charges, they can be kept in the system a lot longer, which is problematic because that means they can be exposed to either going to YDC or other dispositions, or going back to YDC, for more time, assuming it doesn't run afoul of jurisdiction. We haven't really thought this through so much. What I will say, and folks can disagree, but I know Yolanda and I were talking to some folks the other week about this, that, and one reason we're talking about it in the context of first-degree murder, or certainly serious level felonies, is, this might be an ability to get a case remanded or returned to juvenile court, because you can talk to the prosecutor about, well, they're going to have to spend 3 years on probation, or they're going to have to spend 3 years on post-release supervision. I mean, I don't know if that's just sort of, I don't know, guesswork on that, but it gives you a little bit, I think, more room, even though if they're just going to be in juvenile court, what is typical in our arguments is, if you're not going to adult criminal court, all this stuff is bad, right? But if you have the opportunity, versus keeping them in adult court to get them back to juvenile court, then this is good, in theory. So we just wanted to make sure folks saw that. And again, whenever we post this video, we'll have this section as well as the other section. I know it's a little incongruent, but we just decided to tack it on. Sorry. Any thoughts or questions about those two pieces of legislation before we wrap up the whole call? I'm not seeing anything in the chat, I don't think, or am I missing something? All right. Well, if there's no further questions on either the appointment process or on this new legislation, again, I just want to say a few thank yous. One, as always, to the office for all the work that you do. Two, to IDS, specifically Chad, Whitney, Max. There's a lot of folks at IDS, and of course Mary Pollard for helping us get this change through in the commission. Hopefully they will have final approval next Friday. Yeah, just thanks everyone for coming. Again, we're all going to go on this journey together. We're going to learn together, but always feel free to contact myself and others in the office if you have any questions. All right. Well, it's a few minutes after 2. Thank you for coming on this Friday afternoon. We will be in touch with roster members soon on the details. We will be in touch otherwise with other folks. If they have any questions or concerns, they can always contact us. So thank you everyone for coming.